Okay, so should we start now? We have around 25 participants. They're coming up more and more, but I'll include them into the meeting. So first of all, I want to say good morning, right? And thank you all for being here with us today for this 1 hour webinar on data protection. So today's objective is to provide you with an update around the Swiss Federal Act on data protection, but not only, as we will also talk about European and American regulations. So please bear in mind that there is a chat here, which is available. So if you have any questions, please feel free, and we'll try to address some of these at the end of the webinar. So before starting, I will now let our dear speakers present themselves.
Good morning, everyone. Nice to see you all here. My name is Caroline Perriard, and I'm the co-CEO of Branded. Branded is a company who is providing legal consultancy in regards to data protection and intellectual property. So we are advising companies in their digital transformation, their e-commerce campaigns, and any other, let's say, projects that include data as an asset of the company and IP on the other hand.
And hi, everybody. Good morning. So I'm Julia Lustig, and I am a solutions engineer based in Paris for OneTrust. So OneTrust is one of the global leaders in terms of privacy. So we create solutions to help companies stay compliant and use that as a competitive advantage.
Thank you, Julia. And my name, I am your host and speaker today, is Giancarlo Avoglio. I am a manager at Colombus Consulting, and we assist companies and organizations from the launch to the delivery of their data initiatives. So we have a broad experience and expertise on this matter, ranging from data governance and privacy to management, analytics, and much more. So should we start now our presentation? I have automated all people joining us. So if you will, without further ado, let's have a look at our agenda for today. So we have our first 30 minutes in which we will review what's new around data protection, with a focus on the impacts of the revision of the Swiss FADP. The following 15 minutes, we will see how software solutions such as OneTrust can help accelerate compliance. And then for the last, let's say, 10, 15 minutes, we will have our Q&A session. Hope this is okay for all of you. So let's start. Without further ado, I will pass it on to Caroline, who will give us an overview of what's going on around data protection today.
Thank you, Giancarlo. So when we talk about data protection, we talk about personal data. This is what is protected under the legislation. It's data that is identifying someone or that is making it possible to identify a person. There are different type of data. The first party data is the data that you collect as a company through your own campaign, through interaction with your customers. The second party data is data that is coming from your partners, different entities you might be sharing information with. And the third party data, this is the external data that is coming from the different providers where you also interact on with your digital marketing, the social media platforms, maybe data that you buy from a provider, a list of customer name, etc. All of this data is important and needs to be protected. It's falling in your bucket inside your company. It's coming from different sources. So we see it here in the middle, different platforms, coming from mobile interaction, from analytics. At the end, we have this set of data that are possible to identify someone, and it's where we need protection. Yes. Another set we want to mention briefly here, again, because Switzerland has been changing its law, and then Switzerland is adding under sensitive data, the biometrical data and the generic data, is that you also need to consider your company. What industry are you active in? Are you in the medical device, pharmaceutical industry? Are you more a B2B company? What is the matter with the data you might be collected? Don't forget that you also collect sensitive data about your employees. So even if you're only active in B2B and you have less direct consumers interaction, you still have information about your employees that you need to protect. Sensitive data cannot be collected except if you have specific legal basis, such as a consent or a legal ground, an obligation where you need to store it. Yes, Giancarlo. But what is interesting is also to understand where are we today with the legislation. You know GDPR, you know kind of the story. We have been I wouldn't say partying, but enjoying the 3 years implementation of GDPR by asking, does that matter? Is it bringing anything to the customers and the end user? We're waiting for the e-privacy regulation, hopefully at the end of the year. The draft is ready. It needs now to be accepted at the EU level. The e-privacy will impact your marketing practices because it rules also how cookies and trackers are used. For Switzerland, we have a new law. So the Legislation Act has been revised, is there. We're still waiting for the entry date, so we will be able to implement it. I'm quite optimistic, so I think it will be 2022. But yesterday I was preparing for today. I noticed that some people were a little bit less optimistic and said 2023. Nevertheless, it doesn't mean that companies here in Switzerland can just relax and think, okay, I'm waiting 2 more years, because when it comes into force, then it's implemented directly. There is no transition period. So what are the differences? And we can move to the next one. The fines. Before we move to the difference, I wanted to explain to you why it is important to look at data protection law and what are the risks. Here you have really high numbers. Some companies have been fined with large amount of euro for not respecting the law. I would like to take 3 examples because I think they're interesting. And even if your company is probably a little bit smaller than Google and maybe even smaller than the Facebook one, you will see that it's important. H&M, they've been fined because they were collecting a lot of data about their employees when the employees were coming back after holidays or sick leave. So after leave of the employee, they had some chat and then were running some kind of form asking some question. This information was used for performance review, maybe thinking, is the employee more motivated or less after a leave? H&M were fined because first they were collecting quite a lot of sensitive data. They were not respecting the data minimization principle that the law is asking us to do. And then the access to the data was made broadly among the managers of the firm. So here definitely violation of the rights of the employees. TIM is an Italian company of telecommunication. TIM has been sending overly aggressive campaigns, reaching out to customers by phone, sending a lot of emails. And it was shown that actually they had no control on their database of customer. So they were reaching out to people who had opted out or withdrawn their consent, and they were not respecting the rights. So here really violation of the purpose and also the legal basis principles. And British Airways, this is also another case of spoofing attempt by cyber attacks, who were trying, or we actually did create a website to direct customers of British Airways and collect their data. So they were able to have access to the customer database and redirect the traffic to a spoofing website. here definitely violation of respect or implementation of the right security measures. The fines have been high, and then if you're a smaller company, if you were to be fined in Europe, then probably the amount would be lower, but you still would be fined for the same type of grounds. Yes, Giancarlo. So what are the differences? Can you say, well, we comply with GDPR, we're fine with the Federal Act? Probably almost, if you're already at this stage. The same principle have been taken in the new act. The wording is a bit different, but I would say at the end of the day, we are at the same situation. The appointment of the data protection officer is not required in a similar way as under GDPR. However, you still need to have someone internally looking at how data, personal data is dealt with. And then this will also avoid you to have to go back to the authorities for every new project. So you also need to have a data protection, let's call it responsible internally. If you're an EU company, and then you don't have an affiliate company in Switzerland, then you might, but you still do business, you might still have to have a representative in Switzerland, so someone who is able to pick up the phone or open the mailbox if someone is complaining about your doing. And the main difference is definitely the amount of the fines. In Switzerland, the amount is limited to 250,000 Swiss franc, and it's targeted to the CEO or the director of the company. So the fine is not as deterrent as it is under a GDPR. Nevertheless, if you were to be found to violate some rules, then definitely the impact on the reputation is there. Yeah, next. And a few things to remember here. The principles are the same. The logic is a bit different in the sense that the Swiss law is saying you can process personal data, but you also need to I mean, you cannot do it under certain circumstances, while GDPR is more, you cannot process personal data except if you have some exception, but at the end it's the same application. Switzerland is inserting the high risk profiling, which has a little bit of different meaning than under EU practices. However, at the end of the day, again, it will be the same way of looking at any high risk profiling by running a data privacy impact assessment, for example. The task of the commissioners or the authorities are increasing. However, the authorities are not entitled to order fine, but they will still be able to have you stop processing some data, delete some information, and they will be able to file some administrative complaints before the courts. I mentioned that fine will reach the director or the CEO of the company. It's a criminal complaint, so that's also very important. If you are the data protection responsible in your company, make sure your management team knows that if something goes wrong, they will be the one challenged, and then personally challenge, it's not just the company. Something new also is the duty to inform, which we know. It is the privacy notice, the little disclaimer that we have on the website or when we collect data. Again, from my experience, Swiss companies are quite far away from being compliant here. So the big one probably, compliant with GDPR, but if you're a middle-sized company, just check your privacy notice, and if you don't have any, it's really time to have it there. And then for processes, you need security measures. I mean, those are like principles that are in GDPR and are quite standard. If you start a compliance program, then you will go through that. You will need to be able to show the authorities that you are in the process of being compliant, or you have your data, I would say, in order. And I leave it to you, Giancarlo, I think.
Thank you, Caroline. I would like now to share with you some real-life use cases to highlight the major changes from the revision of the Federal Act on Data Protection. which is largely inspired by the European GDPR. So let's have a look on how the new regulation can impact businesses, but also customers. So of course, this is not an exhaustive list of use cases as we have a limited amount of time. And for some of you who have already worked on the European regulation, this will not be, let's say, totally new. But it is new actually for the consumer in Switzerland. And this will certainly imply a major behavioral change. So our first example here concerns direct marketing. We are well aware of such practices as a prospect or as a client when we are contacted by telemarketeers willing to sell us a product, or when we receive promotional emails from, let's say, different brands. So this will become a major shift for consumers in Switzerland with the new FADP, because as a consumer, I will be obliged to provide my consent. So this is mandatory to share my personal data. Otherwise, it will be quite simple. I will no longer receive any communications, or I will no longer be contacted by these brands, because by default, I am not supposed, right, to be registered in any commercial list without my approval. So this is certainly a new constraint for brands, because before contacting prospects or customers, they will need to collect this explicit consent, which was not really mandatory prior to the revision. And so here we can sum up with new rules of engagement that are being created with tighter but also clearer constraints in terms of communication. So our next example is when we are browsing a website or a mobile application. So brands must notify visitors that part of their behavior is being tracked, and even if they do so just to personalize, let's say, their experience. So the main point here is that brands must now have a cookie consent banner or an ID in case of mobile phones, because it is required that they collect the user's consent as his or her behavior is being tracked, and whether it is for statistical or advertising purposes. Otherwise, they will no longer have the right to do so. So if we do a focus on cookies, there is a subtle difference between the revised FADP and the European GDPR. So even if the main principles remain the same, according to the Swiss regulation, brands must provide informational text and must collect an opt-in, which in this case of the FADP, it does not need to be express. So we can choose how our personal data will be used, whether for statistical or for advertising purposes. So the main difference between the Swiss and European regulation is that in the case of the GDPR, there is a tighter constraint, meaning there is no consent by default, right? So also as a user, I can have the possibility to stop any tracking by myself. So there is a major difference between the two regulations regarding cookie management. And we can say that with the latest directives we have seen from European regulators, this gap will continue to evolve. So our third and last example here is the more complex for companies to manage, which is the right to be forgotten. So this is the case when an individual states that he or she no longer wants to receive communication from a company and no longer wants his or her personal data to be used. So in this case, data must be purged or deleted. but with the exception, of course, of transactional data, which is used by contracts, or in the case of specific verticals where the conservation is required by law. So this is very easy actually for the customer to ask for the exercise of this right by just writing an email directly to the company's DPO. But as we have seen on the other side, it is quite a nightmare actually for companies to purge such data, because let's say that the IT environment is by nature designed to manage data and not really purge them. So another elegant solution would be to anonymize this data, but in general, this requirement remains a real challenge for IT managers. So these were the 3 examples that we wanted to share with you to provide some real life use cases for the consumer. So next, let's have a look of on the corporate side with the compliance toolbox. So by toolbox, I mean in terms of framework and deliverables, and not in terms of solution, because these will be, of course, presented later on by OneTrust. So we'll have a quick look on what we should take into account so these privacy requirements can be properly met. So let's go through the 3 pillars of compliance. So data governance is a very important topic which should not be underestimated. It goes way beyond data protection or data privacy, because every organization must have a governance of its data processes, right? So, and be able to manage them appropriately. So we see a lot of data governance projects. There are launched following data protection initiatives. And so this really highlights the challenges of governing data in general beyond the personal dimension, right? So including data related to products or contracts, which enlarges the scope considerably. So if we move on to the user experience, so as we have previously seen with the example, to provide a proper experience, we must anticipate the requirements, right? So for instance, some companies in Europe have well worked on this side and have even developed a competitive advantage thanks to this, by being transparent and communicating with their end users proactively. The third pillar, sorry, is the IT architectural one. So as we have seen with the right to be forgotten, this is where and how we will implement these changes, which are often technically challenging. So if we have a look on the rollout, and we have here some of the key steps by pillar, but again, these are not exhaustive, and they can, of course, vary from B2B to B2C companies. So when it comes to data governance, some important questions we should ask ourselves is, how will I define the processes to manage data, and how will I integrate with my partners and stakeholders? So the marketing team base, which is a great asset for marketing professionals. So how will I manage it efficiently, right? In the case of user experience, the notion of design of the experience is very important. So for instance, in data privacy projects, we see that A/B testing, for instance, can really maximize the opt-in. So the way we present and communicate with the customers can greatly impact the results. And finally, the IT architecture. So one of the main questions here is, how will I break down the existing silos? How do I centralize and manage master data? And of course, different solutions as is. So ranging from consent management platforms to master data management. And so what is important here is to identify and understand your specific needs. So now let's have a look and an overview on the main deliverables. So regarding data governance, the data register is really key because it is the starting point for managing data. And another important deliverable is the privacy impact assessment, because every project must be assessed based on this document to see if personal data is being generated. So this includes also, of course, data from employees or partners. And we have also the data transfer agreement to define the terms and conditions while working with our business partners, which is also important to understand who will process and control data. So regarding user experience, here the migration of consent is really key. We can illustrate this with the fact that in 2018, with the GDPR, we all received some strange emails from brands telling that they loved us and that they, with the new regulation, we could provide our consent. And so this communication was often unclear. We didn't really understand the reason some of these brands were reaching us. And in fact, these messages were perceived as spam because in fact, they didn't really anticipate this need. So it is important with the revised FADP to be able to prove to regulators that we have also collected consent from the users. Otherwise, we can no longer communicate with them once the regulation will come into force. But what is really important here is how I manage my opt-in base and making sure it is properly migrated with the right level of consent. So I have to define the right strategy to do so. Well, regarding the RT architecture, this is a very broad subject. What matters here really is that there is plethora of solutions. So how will I select the proper tool with the required features to do the job is really important. So if we share with you one of the main best practices that we have seen at our clients, this one is to offer a preference center. So offering a preference center has many advantages, right? Because it is basically a win-win. So for the brand, in terms of data centralization and consent management, the brand will have a 360 view of the customer if it is provided with an omnichannel approach. And for the consumer, as we show that we manage data, we show that we are using data for particular usages, we are transparent, so we are able to reassure the consumer is always in control and that as a company, we care about his or her data. So to provide you now an idea of how to apply some of these concepts in a corporate environment, I will pass it on to Carolyn.
Thank you, Giancarlo. So I think Giancarlo was able also to demonstrate to you why it's important to use it from a marketing point of view, because again, at the end of the day, you want to be able to talk to your customers and know to whom you can talk and how you can optimize it. From a business perspective, and you can move to the next one. Thank you. We wanted to explain to you a case we had with a client of ours who came and said, well, we need to be compliant, not just because we like to be compliant or we said, okay, that's what we need to do in 2020, but we are filing an RFP or we're filing, we're participating to an RFP to get a mandate from a large customer. And this customer is asking us a lot of questions about data protection, and we cannot answer to this question because we are not ready and we don't have the right documentation in place. So this company was an international group with several entities in Europe and outside Europe. They were working in a highly competitive sector. They didn't have a strict process with regard to the protection of personal data. They were probably managing okay, I would say, on an ad hoc basis, but nothing put in place. They couldn't evidence any documentation, written documentation. They didn't have anything on their website explaining kind of to the world how they process data. And across the group, they didn't have any agreement that were allowing them to share information and transfer data. So what we've done was actually rather simple, but there are a few steps to take and follow. The first one is really starting with the mapping of the entities. Who is there? Who is doing what? Who has access to what? Who needs to have access? It sounds easy, but sometimes it takes a lot of time to do this because we don't realize how much personal data is shared among entities of a group. Then we did a data inventory, as also Giancarlo was mentioning. It is important to have this this inventory, and Julia will also come later with the different tools to do that, which is also a list of the different activities we do in HR, marketing, finance, sales, to process data. We did update the agreements they had. Oh, sorry, can you just come back a little bit? We did update the agreements that they had with the different providers by having the right data protection clause in it. We worked on the website compliance with the privacy notice and the different disclaimers that are needed when you have a contact form, when someone wants to register for a newsletter. And then at the end of the day, we were also able to value these efforts by saying, you will now be able to go into all the RFPs and ensure that you have done the work, and then your company is more valuable because then you know how you're doing things. So also think about all of this compliance program as an added value that you will fund your company, and not just as something you need to go through and tick the box. Yes, thank you. Any compliance program, according to our knowledge, needs to follow steps. You need to have a pilot in the plane, definitely a DPO or a team. Team is also okay. The mapping I mentioned is very important. And the third step is the priorities. What industry are you active in? What are the priorities? Sometimes it's easier to say we need to start with the website. We need to start with the third parties. We need to start with the employees' data. And then you can really plan your program in a way that is not overwhelming. The risks are important. They definitely depend on your industry and on let's say the maturity of risk, or the risk you're ready to take within your company. There will be always risk of cyber attacks, etc. It's how you can mitigate them and how you anticipate this risk. And finally, the process that were also raised by Giancarlo and will also be raised by Julia. It's important to have processes in place. It's not just one-time shot, but it's a long-term project. It's a never-ending project, honestly, to say it this way. And you need also to plan this in your budget and in the resources you have. And the last point I want to mention, on the next slide, is the abandonment of the Swiss-US Privacy Shield. So last summer, we learned that Europe was and authorities were denying actually the validity of the US Privacy Shield, the EU-US Privacy Shield, which means also that Switzerland followed and said it's not enough. This framework or mechanism is not enough to protect the right of our individual and residents. So we need to find another solution. There are alternatives, and in this month of June, we got the new standard contractual clause from Europe that will be also recognized by Switzerland. So that's a good news. And then the Data Protection Commissioner in Switzerland has also released the guide, and I will put the link into the chat later, on how you process personal data with providers located outside the EU, outside Switzerland, who don't have an adequate protection level for personal data. So this is a whole new topic. I know some people here, especially in big companies, they're quite involved with that, because there are 18 months now to change, for example, the standard contractual clauses. But I would also say here, take one step after the other, and then assess with whom you're working. Last point, I would say, if you can choose between a US provider and an EU provider, from a legal side, it might be a little bit easier with an EU provider, but that's my personal opinion. Thank you.
Thank you, Carolyn. So please bear in mind that we have here a chat. So if you have any questions, please feel free. We'll try to address these by the end of the session. So if I can conclude, let's say, before Julie's presentation, I'd like to share with you 2 examples of big companies that, because data protection, let's say, matters to us as consumers, but also, of course, matters to big tech, right? So the GAFAs. And so here in this case, what happened to Facebook some months ago with WhatsApp, when they reach users for consent regarding new privacy policies, we have seen that many chose actually to leave this free service. So what we need here to keep in mind is that in general, consumers are increasingly aware of their data rights, and they no longer accept all kinds of practices or policies. So if I move on with the next example, which concerns Apple, we have here the example of the IDFA, which is the identifier for advertisers, which can now be blocked by default with the new iOS. So why is this important? Because it implies a major shift for ad firms and app developers, as the consumer that is, let's say, not really data savvy or well informed is likely to block this feature. And this means that, of course, these companies will have less tracking capabilities, but also less data for brands to analyze. So in this case, Apple, we can say, would have more power over the data within their platform. So why not, let's say, progressively become a one-stop shop for user data? So this is one position that can be put in place. So we will not share really our position on that, but what is important here is that, of course, it is important to keep these changes in mind because we have a really evolving environment. So what I'm going to do now is to let the floor to Julia, who is going to present you the solutions from OneTrust.
Thank you, Giancarlo. All right, so let's start talking about OneTrust. So who are we? Who is OneTrust? As I mentioned briefly in the beginning of the presentation, so we are one of the leaders in terms of solutions to help every single company be compliant on various different use cases. So how do we exactly do this? We first of all start with understanding your data. So how do we do this? We connect with all of your different solutions internally to understand where your data sits, where it's being transferred, whether you're compliant or not. So really understanding your data is the first step. And then the second step really is to then, once you know where your data sits, how can you be compliant? And we do this through our OneTrust data guidance platform, which really helps you understand, where you need to, where you need to fill the gaps, basically. And then once you have this middle piece with both knowing your data and knowing your laws, then we can start also completing everything with all the different use cases that we have, starting from the most important one, the OneTrust privacy. This is the one we started from in the beginning. And it is, I'm really sorry. I'm just going to stop this for a second.
Okay, we had some technical difficulties. This is, of course, the very well-known demo effect. So Julia will be coming back.
Sorry, sorry, I had a little music problem in the background. So the privacy piece here on the top right-hand side, which is basically covering anything that has to do with Article 30, your data mapping, basically. And this is usually for, the security teams, but also most importantly, legal teams or DPOs. But then we also cover, very importantly, on the right-hand side, right next to it in gray, we have OneTrust preference choice, which really covers anything that has to do with getting consent from your customers. So consent on your cookie banners, but consent also in terms of marketing, the newsletters that they're getting, everything that we just spoke about earlier as well with Giancarlo and Caroline as well. So yeah. So we cover that as well. Very important as well is the OneTrust data governance. The data governance piece is anything that has to do with data catalog. So understanding where your data sits, but also in every single, team within your whole company, and understanding also what the different metadata you have as well, to make sure that you're compliant and that you're not overstocking, but that you're also purging the data that you don't need. And then we also have OneTrust GRC, which is anything that has to do with risk and compliance. So it's IT risk, but it's also enterprise risk. So a lot of also important things here. Usually we cover those with the IT teams or the CISO as well. Then we have the OneTrust Vendorpedia in blue, which really covers anything that has to do with third-party risk. So it's not enough to be compliant yourselves with your own data mapping and all of your data, but also understanding who you're working with, who are your vendors, and whether they are compliant or not, or whether tomorrow if they have a leak, are you sure to say that your data is also being protected if that happens. And then on the right-hand side, in terms of ethics, we also cover a big piece here where we also just acquired the leaders in this field, so called Conversant, which we acquired 2 months ago. And that covers anything that has to do with whistleblowing, with the Loi Sapin 2 in France as well. So also very, very important. We're seeing a lot of traction there, as well as OneTrust ESG, which is our latest piece in green that we've also added. So anything that has to do with sustainability within your companies as well. So very, very important. Yeah, you can go to the next slide. Yeah, so the first piece we're really going to focus on today is so anything that has to do particularly with the fundamentals, so privacy, the Article 30 and your records. So how does this work? So you need to keep a data inventory and mapping. So this is also what Caroline also spoke about earlier. But the main importance here is to understand, how many processing activities do you have? Are they compliant or not? Do you know whether there are risks or not? Have you created some DPIAs to really identify all the risks? It's really important. So how we're going to do this with OneTrust is, first of all, we're going to understand your data. So populate your data inventory with, for example, imports or APIs, or plugging into all of your different systems internally. And then create this one-stop shop within OneTrust to have all your data and understand it with a lot of different reportings. Understand once we have this data, we will be able to automate your gap identification. So understand with a lot of intelligence and our AI robotic, which is called Athena, where your risks lie, and whether you're doing any cross-border data transfers as well, because this is really important to know, based on also, again, what Caroline said earlier with Schrems 2 being invalidated last August. You need to know whether you are doing any cross-border data transfers of your processing activities to the US. So then we also have we generate reports and have this really nice, we visualize data on these really simple to use dashboards, where you'll be able to create all of these cross-border data maps, understand how many processing activities you have, which one are at risk, and understand whether you need to do any PIAs or DPIAs, and where all your data lies in different countries. And then, of course, last piece, maintaining compliance. So being able to send out these PIAs or DPIAs automatically when, for example, a processing activity has a high level of risk, being able to be, right on time and having OneTrust basically do this automatically for you. So sending out a PIA based on this processing activity because it's intelligent and it knows that there are high risks involved. So it will really take out all of that manual piece for you and make it easier for you to know where you're at, whether you're maturing in terms of all your processing activities as well. And so this sits on a privacy architecture, which is completely dynamically linked. So throughout time, you'll always be able to, follow through with all of your different processing activities, make sure that, everybody else in your company is also helping you with that through assessments as well. So we're going to talk a little bit about that in the next slide. Oh, a bit further. So first, the mapping. So we have an asset map, which again will help you understand where your data sits. So in a very nice view, you'll know, for example, here you can see you have 9 different assets, and assets are IT or different types of places where you hold data. So this could be Microsoft Outlook if you're using Microsoft Outlook, for example. It could be a Salesforce if you're using it as your CRM, and where it all sits. So you can see here, for example, in the US, we have 9 of those. And then I believe 1 in Switzerland as well. And then for the cross-border data map. So again, you need to be able to say where your data sits, but also whether you are doing any data transfers, especially outside, so from the EU and through to outside the EU. And right now also the big talks are about Schrems 2 being invalidated and the SEC clause as well. So being able to know whether you're doing any processing activities that have this cross-border flow. And I just wanted to point out here, because I know that with the experience that I've had, a lot of our customers sometimes say, yeah, but we don't do any cross-border data flows with the US. Yes, okay, maybe not straight away, but do you use Google? Do you use Microsoft? Most of those have servers in the US. And if you are using them and the servers are in the US, then technically you are doing these cross-border data transfers. So I would say a lot of companies even don't know that they're doing these cross-border data transfers yet. So that's something you really need to get, visualize first and know, and then be able to be compliant to 100%. And then we have this nice data lineage flow chart. So this will really help you with each and every single processing activity. You'll be able to know what the data lifecycle is for this processing activity. So where your data comes from, so which type of consumers you have, and then the source of collection of the data, all the way up until the archiving or destruction of your data. So this is really a nice, clear view to be able to send out to your different teams. We often see this, through my experience, I see this also with IT teams. When the DPO says, yeah, my other teams don't really know what I'm doing. This is really helpful for the IT teams to be able to understand, what's happening within the company and how is the data being transferred. And then gallery wise, so also wanted to mention that within OneTrust, we have a very big gallery of different integrations that are out of the box. So we have about 500 integrations that already exist. And those could range from, IT applications to servers to, databases, things like that. So, we can really connect also to all of your different internal systems in order to discover and understand where your data sits, and then bring it all back into a single source of truth, which is OneTrust. In terms of PIAs and privacy by design assessment, so that's something also that we see going more and more, with time. It's becoming very, very important, especially within, the GDPR as well. So this will also be something you will be able to do with OneTrust. Yeah, So through assessments, you'll be able to assess privacy by design questionnaires to understand whether you are doing this privacy by design from the start or not, whether you're compliant on all of your different processing activities and also your assets, so your IT records, and then also be able to bring out these PIAs or DPIAs. So this is just an example to show you how an assessment could look like. We have really these amazing types of assessments where you'll be able to send those out to your different teams internally, but also externally. So the users don't need to be on OneTrust to answer these questions. But the point here really is to understand whether if tomorrow your HR team is doing a new campaign to recruit people, well, they are doing a new processing activity and you need to be aware of that. So what happens is you can send them this assessment. All they need to do is fill it out and then you'll get it back with the answers. You'll be able to review it and then, and then follow through with it and submit it. And once that's done, then it will automatically populate back into all of your processing activities or create a new processing activity for you. So we don't have a lot of time, but I think this is also a very important piece to mention. So the cookie consent, this is something that, again, OneTrust does very, very well. We are the #1 CMP, so consent management platform out there, which is the most used in the world. We cover all types of different industries and whether large or small companies as well. So the way we do this is really, first of all, we scan websites to understand what your trackers are. So cookies, but also tags and different types of things that are on your website. And then we categorize those automatically through our robot called Cookiepedia. And then we'll also be able to help you with anything that has to do with the banner and the preference layout with really, really simple clicks. There's not a lot of, heavy customization that you need to do. There's basically none. It's a lot of clicks. So it will really, help you get on board really quickly. We have the cookie auto blocking as well, which will automatically block all the cookies where consent are not given. So this is also important to prove this. We have a dynamic cookie policy as well. So the cookie policy will automatically adapt itself every time you do a new scan on your website and new trackers are being found. And then the last piece, which is also the most important, is understanding through reports how you're doing on your cookie banner and all the consent that you're getting. So how much consent are you getting on your cookie banners, the A/B testing that you might be doing on your banners, and then also the amount of consent you're getting, throughout. So this is just a quick view on how it looks like on OneTrust, but just know that it's the audit and you'll be able to redo this audit as much as you want. You'll be able to get back all the different types of cookies, internal cookies, external cookies, so third-party cookies as well. And you'll be able to also export this, this view as well. And so these are the different things that you can do. Also, just wanted to mention, we have a multilingual option. So of course, we cover almost all the languages in the world to be able to, make sure that you're, responding to all of your clients worldwide, and also not just the language, but also the consent model option. So opt-in, opt-out. It's, I know we're speaking mostly in Switzerland now about, very closely related to GDPR. So we have this consent model, but we have also other consent model options. And again, as I promised you earlier, it is a simple click. So this is how it looks like to create your banner. You really just choose your positions, and then also the reports that you'll be able to find here with a lot of nice dashboards, and you'll be able to do some A/B testing here as well. Vendors as well. So last piece here on the vendor side, wanted to let you know that we do basically everything that has to do from the beginning, starting when you onboard a vendor all the way through to offboarding a vendor. So we have here nice dashboards that will also show you, the critical levels of the different vendors you work with, whether there are risks involved as well, or, other types of things here. and of course your vendor list understanding. For this particular vendor, for example, here we see it's Atlassian, where you sit. So in the workflow where we completed the evaluation, and we also found all the risks that were related back to Atlassian. Yeah, and next piece, pre-completed assessment. So we have, yeah, you can go to the next slide. We have about 65,000 vendors that already exist in our exchange piece in Vendorpedia. So this means that, more with time, more and more of our clients ask us to add some more vendors. So just know that here, what's interesting is that you'll have a full view on each of these vendors. So if you go on the next slide as well, Giancarlo, yeah, you'll be able to here view the different certificates that your vendors hold. You'll be able to send them specific assessments, whether, if, as you see here with OneTrust data guidance, you'll also have a lot of different articles, the latest articles that will talk to you about, the fines that were sent out to Google, all the different interesting facts about Google in order for you to be able to understand, where you sit with Google and whether, there's been a leakage of data or whatever, and then you can also send them assessments.
Perfect.
And that's it.
Thank you very much, Julia, for the presentation. And now let's see if we can address some of these questions, because we are running out of time. So many people here asking us if the slides will be shared after this meeting. Of course, everything is being recorded and will be provided for you. Do the other participants see questions that they are willing to address? I might have one here, which says, okay, this is a tough one. It's a very good one. How long does it take for a company to be compliant? Wow, this is complex. So I think that one of the factors might be your business activities, right? So your customer base. So if you are already working with EU residents, you have already done most of this GDPR compliance, it will be fairly easy for you to be compliant. But if you are, let's say, a Swiss company and you have only Swiss residents, that will take a little bit more time, and it will also depend, of course, on your size. So a startup could start with some deliverables around Microsoft PowerPoint and Excel sheets, etc. But if you're, let's say, a Fortune 500, so a very large corporation with multiple partners and so on, their consulting assessment might be required. So we could talk here about a mandate around, let's say, 100K. I hope this was clear for you as an answer. Do we have other questions? We have 1 minute left. Okay, perfect. We have no more questions here. I will then leave you guys to go back to your activities, and I am willing to thank you all for participating to this webinar with us. And please make sure that if you have any questions later on, you can reach us on social media. Thank you all.
Thank you. Have a good day.
Thank you for your time.